Everyone, my name is Haley Bell. Today we're going to be discussing the process of plea bargains. I guess we could just go ahead and jump on in. First point of discussion is to explain the plea bargaining process. So the plea bargaining process consists of a negotiated agreement in lieu of a trial, or as Alan Bowman, a defense attorney, stated, a plea bargain is a circumstance for your client to materially benefit from a negotiated disposition with the government in order to get more than they deserve in terms of a concession. Around 95% of criminal cases will end with a plea bargain and will not make it to trial due to the certainty that plea bargains offer for the defendants, defense attorneys, prosecutors, and judges, as the charges and sentences will be agreed upon prior to a conviction. Plea bargains are essentially just contracts made between defendants and prosecutors in which defendants will agree to plead guilty or nolo contendere, which means no contest and signifies that the defendant is not pleading innocent or guilty towards the responsibility of the charges, but that they do accept the punishment. During this process, the defendant will agree to some or all of the charges against them in exchange for concession from the prosecutor, and oftentimes individuals who plead guilty and accept plea deals are more likely to receive a less harsh sentence than those who invoke their Sixth Amendment and do go to trial, because prosecutors are able to offer a less harsh sentence because they have a wider latitude than judges who have a concise sentencing guideline that they must follow. A conscious issue within plea bargains, however, happen to be that innocent defendants are more likely to accept plea bargains in order to go home that same night rather than asserting their rights and waiting the 6 to 18, sometimes even longer months it may take to face a trial. The next point of discussion is to list the elements of a valid plea bargain. So there are 3 essential components to the validity of a plea deal, which include a conscious waiver of rights, the waiver must be voluntary, and the criminal charges must have a factual basis. Next, we have defined the role of a judge in the plea bargaining process. So according to Albert Alschuler, 1976, the judge's role is not that of one of the parties a part of the negotiation, but that of an independent examiner to verify that the defendant's plea is the result of an intelligent and knowing choice and not based on a misapprehension or the product of a coercion. A judge is required to ensure that the defendant is advised of their charge or charges, the potential consequences of the guilty plea, and the rights the defendant is waiving by pleading guilty. During the plea colloquy process, the judge will then ask a series of questions to evaluate whether the defendant's plea is knowingly, intelligent, and voluntary. This process was established following the Boykin v. Alabama 1969 court case. Additionally, judges need to review and approve the plea agreements prior to it being finalized, meaning that judges have the authority to reject and accept each plea bargain. Judges can also accept a partially negotiated plea, which is where a judge accepts a part of the agreement but not all of it. So, for example, a judge may not agree with the predisposed sentencing of a plea bargain and can introduce a different sentence. If the term of a plea bargain is changed, the defendant will then be able to withdraw their previous guilty plea. Lastly, we have create and provide an opinion on whether plea bargaining is a benefit to the United States criminal justice system and why. I do believe that the plea bargain was a large benefit to the United States criminal justice system because it did help to keep the system from becoming overwhelmed. There are not currently, nor will there ever likely be, enough resources in which hundreds of thousands of criminal cases will be able to be heard at a trial. And this is largely due to the limited number of judges on the bench, and there are not nearly enough jurors to serve every trial. Similarly, all of these trials would be on backlogs as it would take years to get through every single case. However, due to plea bargains being so heavily influenced by the prosecutorial discretion, biases are likely to be experienced and the result can lead to unjust sentencing. The reduced charges a defendant may be offered within a plea deal can drastically differ depending upon one's race, as Black individuals were less likely to receive reduced charges and shorter sentences compared to white individuals, and these consistent disparities are due to the prosecutorial discretions. Additionally, there are numerous alternatives that could help to reduce plea bargains, one of which could include a jury waiver system or a bench trial, which is a system in which the defendant may be able to waive their right to a jury in order to still have a trial and be able to argue their case to a judge, which would be a great option for innocent individuals who may feel the need to plead guilty because they have been informed that the evidence gathered could be enough to sentence them for much longer than the plea bargain. Additionally, one of the main issues with plea bargaining is that according to the unconstitutional conditions doctrine, the government cannot condition a benefit on the recipient giving up their constitutional right. So during a plea bargain, the defendant is offered the benefit of a reduced sentence under the agreement that the defendant will plead guilty and waive their right to a jury, or they will then be threatened with an increased sentence if they choose to go to trial. An argument could then state that plea bargaining is unconstitutional and that it does go against an individual's 5th, 6th, and 14th Amendment. So, thank you.